Hi, my name is Jim Collins. Thank you for joining me for this webinar on covered business method patents. What we'll be talking about today is Section 18 of the Leigh-Smith American Invent Act that provides for a special challenge to a specific type of patent, and those patents are called covered business methods. The covered business method patent is a patent that's directed to methods or corresponding apparatuses that perform data processing operations that are used in the practice, administration, or management of a financial product or service. Now, the patents eligible for this program are those patents that issued on, before, or after the AIA was passed. And that was September 16th, 2012. Actually, the program implemented on September 16th, 2013. Now, the patents that are eligible for this program are those that are first to invent, so those occurring before the program, as well as those occurring after the AIA, and that's those patents that were first to file. Now, the first to file patents have a safe harbor period. In other words, a patent issuing that was based on a first to file system is not subject to a covered business method review within 9 months of issuance. The reason why they're not subject to a covered business method review is because they're subject to post-grant review. So now, who can file under this program? Well, parties that have sued or been charged for infringement. And the patents that are asserted are covered business method, provided they're not technological inventions. Now, a financial product covered by this program has been defined by Congress and has been defined by the board as well. Congress tells us that a financial product, according to Senator Schumer, is any patent claiming activities financial in nature, incidental to financial activity, or complementary to financial activity. When the board looks at a patent or looks at a petition, it'll look to the claims, the specification, and the prosecution history. Now, as we look at the written description in a negotiation that took place during the prosecution of the patent to determine whether that patent is eligible, and if it's financial in nature or incidental to a financial activity, it will be considered a financial product. It will be considered covered under this program unless it's a technological invention. So, what is a technological invention? Well, a technological invention is a patent that claims a technological feature that is novel and inobvious over the prior art, and it solves a technical problem using a technical solution. Examples of a technological invention would be a novel and inobvious hedging machine for hedging commodities. However, a covered business method, an analogous covered business method, would be a method of hedging risk. Those patents would be eligible. A process for verifying the validity of a credit card transaction would also be eligible for a covered business method. However, a novel and an obvious credit card reader for verifying credit is not eligible. Now, Congress codified the prior art that can be used in this program because it's limited to a specific type of patent. That's the covered business method. Now, the art that can be asserted against these patents are basically 102A art, and it's 102 and 103 art. So the 102A art is the pre-AIA art. In other words, the 102A that was in effect prior to September 12th of 2013. What is that? That's shown on the slide. So it's prior art that shows public knowledge or use by others before, in the U.S. before the date of invention, patented or printed publications anywhere in the world before the date of invention, and a hybrid between 102B and 102A. In other words, it's prior art that discloses an invention 1 year before the date of the application in the U.S. that would be described as 102A art if the disclosure had been made to another before invented by the patent application. So what is the threshold for this program? Well, the statute tells us the threshold is if such information in a petition were not rebutted. Would it demonstrate that it's more likely than not that at least one of the claims challenged in the petition is unpatentable? So the statute says that all the board needs to look at is the petition. However, the board follows Rule 42208. And that rule tells us that the board will consider or take into account a patent owner's preliminary response. So the threshold will be the case that the petitioner provides in his petition and the patent owner's preliminary response, should it elect to do so. So the board will consider the patent owner's preliminary response, and if it finds that only one claim of any claim in the patent is a covered business method and a patent isn't directed to a technological invention, that patent will qualify. So the timing for the program is shown in this slide. It's a very fast-paced program. The implementation shows that discovery occurs in a sequential order. We'll provide a quick or a broad overview and then look at each one of these events that are shown on this timeline. As you can see, the process begins with the petition, which would be the defendant in the lawsuit of the individual charged with infringement. Once the petition is filed, the patent owner is given 3 months to provide a preliminary response. Now, this is an optional response should the patent owner elect to respond to the petition. If the patent owner elects to do so, it'll file its response within 3 months of the petition, and then the board is given 3 months to evaluate and analyze the different positions to determine whether it'll institute. The board is given 3 months to do so. However, for the most part, the board has been taking 1.5 to 2 months to arrive at its decision. Once a decision to institute trial occurs, by statute, the trial must last no more than 1 year. As I indicated, this process begins with a petition. It's a government agency, so naturally it begins with the payment of a fee. The petition must also identify the real parties of interest. It must provide a statement for the relief it seeks, supported by the evidence. The petitions, for the most part, will include claim charts. Why? Because the petitioner must identify with particularity the grounds as to why the patent owner's claims are unpatentable. Petition will include claim constructions. Now remember, the claim constructions here are broadest reasonable constructions. So it's the constructions that the Patent Office provides rather than the constructions provided by district courts. It's not plain and ordinary meaning, it's broadest reasonable interpretation. Now the petitioner can also provide testimonial evidence in terms of affidavits. However, with those affidavits, they must disclose the underlying facts and data for those opinions. The page limit is 80 pages. A point that is often missed at this stage after a petition is filed, and actually once trial is instituted, is a patent owner within 10 days must file any objections they have to the petition and the testimonial evidence. If the objections are not served on the petitioner within 10 days, those objections are waived. So what are the common mistakes that occur at this stage? Well, not necessarily at this stage, but upon the institution, the patent owner may fail to serve objections. From the petitioner's perspective, it's a failure to provide good declarations. They don't show how a person of ordinary skill in the art understands the art or provides a basis for providing their opinion. Oftentimes, the petitioner will provide too many grounds of unpatentability and fail to articulate a meaningful difference between those two. If that occurs, the board has shown itself that it will disregard those bases and will not hold a trial on those grounds. Another problem that we've seen is a lack of coherent claim construction. Remember, this is an opportunity for the petitioner to frame the trial. And they get the first brief. They get the first document. This document can establish the basis for the trial. It's important for them to establish their claim constructions. Now, as I mentioned, the patent owner is given an opportunity to respond. It's an optional response, and that response occurs 3 months after the petition is filed. If a patent owner decides not to respond, no adverse inference will be taken. Furthermore, if the patent owner wants to expedite the process, they can file a waiver, which will then expedite the process, and the board will consider whether to hold a trial within 3 to 4 months of the petition. Now, at the preliminary response, the patent owner cannot provide any claim amendments. However, they can disclaim claims to streamline the process. At this point, the patent owner is responding with one hand tied behind their back. Why do I say that? Because they can't provide any testimonial evidence. There is the condition that unless authorized, but that condition is met only under the highest standard, and that's under the interest of justice. So how might the patent owner respond? Well, they may address the prior art. They may address standing. They may address the real party of interest, but they must do so within 80 pages. Okay, upon the issuance of the decision, the board will specify the claims for the trial, or the basis for the trial. It's non-appealable. At this stage, a party can move to consolidate. They can move to stay. They can move to transfer. If re-examinations or reissues are occurring, they can move for a stay. 2 weeks after the issuance of the decision, oftentimes the board will have a teleconference in which a preliminary scheduling order will be entered. The parties will also be expected to submit a list of motions. Now, this isn't exhaustive. The parties will be given another opportunity to request motion. However, they'll need to require leave if they decide to do so. If the patent owner found that it needed to file some supplemental information, it must do so within a month of institution of trial. Now remember, at this stage, estoppel hasn't attached. Estoppel only attaches upon the final written decision. The PTAB takes a very narrow view of discovery. Remember when we look at the slide showing institution, that it's shown is sequential discovery that becomes with the patent owner. The board generally allows routine discovery. What is that? That's discovery on any art cited or exhibit cited in the paper or testimony. You can take discovery on those papers. You can also cross-examine any declarants. Now both parties, both the petitioner and the patent owner, are expected to disclose relevant information that is inconsistent with the position advanced during the proceeding. No requests are needed. Those must be made automatically. Initial disclosures can also be made. That is, if the parties agreed or if it's ordered by the board. And additional discovery can be sought. However, it's at a very high standard and it's not likely to be authorized. The Garment case establishes the standard that many of the boards follow. It may indicate that the mere possibility of finding useful discovery is not sufficient. And the board often cites to its expedited schedule of having to complete a trial within a year for reasons for denying anything other than routine discovery. So the deposition framework has a number of issues that you should keep in mind. Now, compelled discovery can be taken only during the testimony period set by the board. What does that mean? During the sequential discovery period. So the patent owner will begin with their discovery period. 3 months after the institution decision, the petitioner will be given a 3-month opportunity to conduct depositions as well. Now, the party requesting cross-examination of more than one witness can determine the order of the witnesses. If uncompelled testimony is needed, it's by agreement of the parties or by order of the board. Now, the duration of these depositions are 7 hours for cross, 4 hours for redirect, and 2 hours for recross. If a party chooses to take direct testimony, cross-examine direct testimony, the witness must be given, the witnesses must be identified, and copies of the exhibits that will be used during the deposition must be identified or provided. Now, cross-examination is limited to the scope of the direct testimony. What's often missed here from the party defending the deposition is any objections to the admissibility, content, or form or manner of taking deposition must be made at the deposition. Otherwise, it's waived. Now, evidence to cure the admissibility objections can be agreed upon and can occur later on time. Otherwise, it must be made during the deposition. So let's look at the substantive responses that the parties are going to make. After the institution decision occurs, the patent owner has 3 months to take their depositions, complete their discovery, and file a patent owner's response. The patent owner will be responding to the claims addressed by the board and the basis for patentability. Oftentimes the board will identify claim charts, so they'll also be identifying or differentiating the arguments made by the petitioner in their claim charts. Now, the patent owner may include affidavits and additional factual evidence. This is the first time that the patent owner is given an opportunity to provide testimonial evidence. If the patent owner elects not to file, the patent owner must arrange a conference call with the board to discuss filing of an adverse judgment. Why? Well, the board has already found that certain claims are unpatentable. So the board has instituted a trial. If the patent owner chooses not to respond, that is more or less an admission that the claims are unpatentable. And so at this stage, the party would request an adverse judgment on those claims. So the patent owner is also given an opportunity to amend the claims or substitute claims at the 3-month mark. However, this is what I consider illusory, and I'll explain in more detail through this slide. As I said, a motion to amend the claims or provide substitute claims occurs at the 3-month part. The request to cancel claims or amend claims should be made as a contingent motion. Why? Unless the claims are shown to be patentable, the board will not enter the motion. If your motion to amend is not made contingent, the board will understand that motion to have canceled the original claims in view of the amended claims. If it's not entered, the amendment will not be entered, and the original claims will be canceled, so you will have lost those claims. So if you decide to amend the claims at the 3-month mark, make it contingent. Now, at this stage, the patent owner is allowed to amend the claims. However, there's no broadening amendments, and only a reasonable number of claims can be entered. Oftentimes, the substitute claims have to correspond to the number of claims that you're canceling. The reason why I believe it's illusory is that the patent owner must not only explain why the claims are patentable over the art of record, in other words, over the art that the trial is being instituted on, but they also must explain why it's patentable over other non-cited art in the trial. And they must explain why a person of ordinary skill in the art would not find it obvious over that art. So it's a very high burden. You must overcome not only the art in the trial, you must overcome the closest art that you're aware of, and you also must overcome why a person of ordinary skill, knowing that art, looking at your amendments, wouldn't find it to be obvious. It's a very high standard. So the petitioner is given an opportunity to reply to the patent owner's response in opposition to the proposed amendments within 3 months of the patent owner's response. Now the rule says the reply may only the petitioner may only reply to issues raised by the patent owner. And the comments to the rules indicate that replies raising new grounds will not be considered. The rule also says that if you wish to file supplemental evidence, it must be submitted earlier if it's evidence that's augmenting your institution decision, or you must seek leave, and leave will not be granted unless it's in the interest of justice. So this would occur by motion of supplemental evidence. What often occurs is petitioners will often include new affidavits and new factual evidence under the guise of rebuttal evidence. They'll argue that that they are responding to the direct basis to the patent owner's response. So in effect, this is a new evidence. The board's position, at least up to this point, has indicated that it will not rule, at least the decisions made to this point, is that it often will not reach a decision until the final decision is made. The decisions often tell us the proper form to call the board's attention to this is by making the board aware of it through a conference call. They discourage requests to seek motions to file. They request leave to file motions to strike. Instead, they prefer teleconferences. If you're a patent owner, I would suggest that you include a transcript or have the calls transcribed so it can be made of record. If that doesn't occur, it will not be included in the record, and you won't have that basis for appeal or offer your arguments. Now, the patent owner is given an opportunity to reply to the petitioner's opposition to proposed amendments. What we're talking about here is, should the patent owner decide to file a motion to amend their claims, the petitioner is given an opportunity to file an opposition. If they do file an opposition, the patent owner they're given an opposition, the patent owner is then given an opportunity to reply to the opposition to proposed amendment. So the time period to replying to the petitioner's opposition is 1 month after the petitioner files. It's limited to addressing the arguments presented in opposition. It's limited to 5 pages. Now, the board tells us it should not be used as a vehicle for a SIR reply, but the shrewd patent owner can utilize this opportunity to respond and also supplement their case. If, after all the filings, a party is not given an opportunity to respond to a deposition, the scheduling order will lay out an opportunity to file observations. And what an observation is an opportunity for the party to take a deposition of new testimonial evidence that they weren't allowed to respond to earlier and provide observations. An observation is a concise statement of relevance of the identified testimony that's not to exceed a single short paragraph. The opposing party may file a response, however, that must be equally concise. Keep in mind, if the patent owner forgoes the submission of new declarations, the petitioner will not be given this opportunity. Both parties will be given an opportunity to file motions to exclude evidence. It's automatically granted. You don't need to move to file the motion. This occurs about 2 months after the petitioner's reply to the patent owner's response and discovery is ended. It's set in the scheduling order. Now, the motion to exclude evidence is limited to 15 pages. Now, remember, you're limited to exclude evidence that has been objected to, and those objections must have been made in the record. If you're objecting to a deposition, that objection must have been made at the deposition. If it's occurring before trial, in other words, you're objecting to the petitioner's testimonial evidence or something in their petition, it had to have been made within 10 business days on institution. If it's during trial, it has to be served within 5 business days. Now, these objections must be made with particularity to allow for correction of form of supplemental through the form of supplemental evidence. Now, the party relying on the evidence to the objections has 10 days to cure. Now, the admissibility of evidence is governed by the Federal Rules of Evidence. And remember, evidence not subjected to motion to exclude is in. Now, the motion to exclude has certain formalities. A motion to exclude evidence must identify where in the record it was made. It must show where it was relied on. And for the party making that motion, it must address those objections in numerical order and explain each objection. If the parties desire an oral hearing, they must file a request before the board and identify all the issues to be addressed. The date of the oral hearing is set by the scheduling order. All members of the panel will sit for the oral hearing. If exhibits are used, they must be served 5 business days before and filed before oral arguments. The order of the arguments is that the petitioner begins, the patent owner follows, and the petitioner replies. Now, the order can be reversed depending on the burden of the party. Now, no new evidence or arguments are permitted. All attorneys of records may argue. Any arguments generally will not be on the briefings. The arguments will be responding to the panel's questions. We'll cover the file history and the positions your opponents raise. So the final written decision will occur within a year of institution. A party may file a request for a hearing within 30 days of a decision. Why might they do that? Well, it may preserve issues for appeal to correct errors. It allows them to further develop the record. A party may wish to toll the time for filing an appeal. The appeal period does not begin until the board issues its final decision. Now, if it's granted, the board will apply a very high standard, and it's called an abuse of discretion. What is that? Well, examples are it's clearly unreasonable, arbitrary, and fanciful. It's based on erroneous conclusions of law. It rests on clearly erroneous fact patterns. It follows from a record that contains no evidence on which the board bases its decision. Now, with this final decision, estoppel attaches. How does it attach? For the petitioner, it attaches to any ground raised during the proceeding. For the patent owner, it attaches by precluding them from taking any action inconsistent with an adverse judgment, including obtaining any patents. What does that mean? A patent owner cannot prosecute indistinct claims in a related application. It cannot seek to modify the specification or amendments that were denied in another application. So why might you file? You might file because you've been sued. You don't like the venue you're in. You would like two bites of the apple. Remember, in the covered business method patent, unlike other post-grant review programs, estoppel only attaches to the basis of the trial, to the art that's cited. You may want to limit discovery. You want to limit motion practice. You want a speedy trial. Remember, the trial will be completed within a year of institution. You want your district court to stay the case. For the most part, district courts are staying cases. Now, note that the timeline that you saw for the institution in the final decision was approximately a year and a half. The appeal will likely take just as long. So your case will likely be stayed for 3 years. Now, remember, at the patent office, the board gives the claims their broadest reasonable construction. That's much different than what the claims are being construed at the district court. Those are plain and ordinary meaning. Also remember that you may want a lower invalidity standard. It's a preponderance of the evidence standard here. It's not clear and convincing. You also might want to begin your case here or stay your case here because your invalidity case is too complicated. Many of the PTAB judges have scientific backgrounds. Finally, you may want to do it because your witnesses are more comfortable in a closet rather than a live testimony or the live web seminar like I'm giving you today. If you have any questions or would like to discuss this any further, I would invite you to write to me at jcollins@brinksgilson.com. Thank you very much for listening. I look forward to hearing from you.